What is the compliance report?
No, my lord, may I submit this matter? My lord,
Where is my order?
my lord, the order is at page, the operative portion is at page 17.
Page 17.
May I please?
Yes, sir.
My lord, paragraph number 6.
Yes, sir.
In the event any illegality on and or irregularities noticed by the executive engineer Damdam municipality, the said report shall have to be considered in accordance with law by the Board of Councillors of Damdam municipality after serving notice both upon the petitioner as well as the private respondent. And the Board of Councillors of Damdam municipality shall thereafter pass a reasoned order and shall communicate the same both to the petitioner and to the private respondents, either by speed post or by email if the email details are provided at the time of hearing. It is further directed that after completion of inspection, the executive engineer Damdam municipality shall provide a copy of such inspection report to the petitioner as well as to the private respondents, which shall be sent to them under speed post. The entire exercise as indicated above is to be completed by the respondent number 4, that is Board of Councillors Damdam municipality, by the last day of December 2024. It is, my lord, this is the order of your lordship, my lord. Now, my lord, pursuant to a lordship direction, there was a finding of the executive engineer that the construction is illegal. Board of Councillors had taken a decision, and I will fair with the lordship on the 12/6/2025.
So they are supposed to pass a reasoned order.
They are passed. They are passed, and my lord, on 12th June, they were, in fact, my lord, the entire demolition exercise has to be completed. The entire process, up to the completion of the entire process, the order was there.
Where is that order?
My lord, the entire exercise as indicated above is to be completed. If it is, my lord, finally, this is the paragraph number 7. It is further directed that after completion of inspection, the executive engineer Damdam municipality shall provide a copy of such inspection report to the petitioner as well as the private respondents, which shall be sent to them under speed post. The entire exercise that is has to be completed by the respondent number 4, that is Board of Councillors Damdam municipality, by the last day of December 2024. So, my lord, the Board of Councillors has passed an order. Now, my lord, because the demolition program was not completed by them within time, your lordship kept today as for seeking compliance report by them that whether the demolition, they have started the demolition program or not. Now, my lord, on 12th June, I will fair with the lordship, on 12th June, they went for demolition. They went for demolition, my lord. Now, my lord, now the situation starts on 12th June, my lord, the private response.
No, sir, so far internal page number 3 is concerned. I have passed a direction for passing a reasoned order and for communication. So it has been complied with.
The order has been complied with, my lord. In the order, my lord, it was stated, my lord, 60 days time was given for self demolition by the developer. Lord, after 60 days, Lord, the municipality gave a notice on 5th of June that we shall, since the order was not complied, the municipality went for demolition on 12th of June. On 12th of June, my lord, the learned advocate for the private respondents handed over a order of the communication, my lord. That, my lord, they have preferred a civil revision application before the Honorable High Court against the order of the municipal trial court, my lord. They preferred a municipal appeal before the learned civil judge junior division Bidhan Nagar. My lord, the learned civil judge junior division was not supposed to, did not state the order. But subsequently, my lord, they
Say which order?
Did not order of demolition of the municipality.
Acha.
But subsequently, my lord, the private respondents preferred an application under Article 227 before the Honorable High Court. My lord, the Honorable High Court has been pleased to stay the order. My lord, if the compliance report, I have annexed the order.
This court directed the Board of Councillors to pass a reasoned order.
Lordship.
Reasoned order has been passed.
Subsequent to your lordship's last direction, subsequent to your lordship's last order passing the contempt application, your lordship kept today for completing the demolition program, my lord. Now, my lord, I do not say that the municipality is in violation, because municipality went to demolish the building. Now, my lord, the
photographs are annexed.
No, why the contempt will continue, sir? Reasoned order has been passed.
My lord, during the pendency of this contempt, because the demolition was under the session of this contempt court, my lord, pursuant to your lordship's last direction, my lord. Now, my lord, what happened? They have filed a civil revision, obtained an order ex parte, and they have not indicated before that court that a contempt procedure.
No, sir. Order was passed to the extent that to pass a reasoned order, because at that material time the court was not under contemplation that the demolition order will be passed.
Once a demolition order has been passed, my lord, a separate cause of action has arisen.
Absolutely.
My lord,
Take down.
One thing, my lord. My lord, I have written to the Honorable Chief Justice because my lord, this is a judicial issue because the contempt was pending at that point of time when the order was passed. They ought to have indicated before the Honorable coordinate bench from where the stay order was obtained that see a contempt proceeding is pending. They have not indicated that. So for that reason, my lord, I have written to the Honorable Chief Justice to take an appropriate decision in this matter, my lord. So till the decision arrives,
let his lordship take an appropriate decision. Reason order has been passed. What is that reason order?
my lord,
My lord, may kindly peruse the status
my lord, may
report
kindly
filed on
keep
the
the
earlier
proceeding
occasion.
pending for 1 week, my lord. Kindly, my lord, so that I can have a decision with regard to this. I have still not.
No, sir. This court, while disposing the writ petition, has directed the municipal board of councillors of the relevant municipality to pass a receipt order. Receipt order has been passed. It has been communicated. What is the receipt order?
My lord, on the earlier occasion, we filed a status report, my lord. Not the reason order.
Then what is this?
This is a compliance report, my lord. Your lord, since my lord, the demolition was not completed, your lordship.
My reason order was passed on the last day itself. Your lordship kept today for the demolition report itself.
What is my order? Show me the where I have kept that.
My lord, may kindly takes the last order. The last order, my lord.
Yes, sir.
They have sought time for filing a further status report. Your lordship kept today for receiving
Sir,
the
try
status
to
report.
understand. This court passed an order for passing of a reason order. Reason order has been passed. So if reason order has been passed, it has not been complied, it's different course of action.
Take internal page.
Hey, Asuna. Where is that order? What is that order? Status report.
Lord, I beg to appear on behalf of the alleged contemner. But pursuant to my lord's order, my lord, I have been served with the notices of the contempt application, but yet to receive the contempt application yet to.
So I have the instruction to appear on behalf of the secretary if the secretary has been made a party, because the copy of the contempt application has not been served. If I am not wrong, Lordship, on 23rd of May, this matter appeared before your Lordship, and your Lordship directed the
You have not served the copy of the content application.
No, he has served. He has served. In fact, my lord's order records that notices be served. So, my lord, he has possibly served the notice and did not appreciate that the contempt has
Give me a copy.
to
Give
be
me a
served.
copy.
Contempt copy এটা?
By hand.
Yes.
By hand.
কি এটা তোমার?
By hand.
Order. Please enclosed. এক মিনিট দাঁড়াও না। Herewith, a server copy of the order has been, this has been served. You have to serve a complete.
আপনি কি পাঠিয়েছিলেন contempt
Obviously,
application?
by hand delivered.
আর একটা দিয়ে দিন।
এই by hand আছে, by post আছে।
এটা দিলে হবে না, contempt এর copy.
Order has been served.
Contempt application এর কপি আছে?
আমি already I have served that copy.
আপনি কি আমার কথা বুঝতে পারছেন না?
I have.
হিন্দি মে বলবো?
না, I have the copy, Lordship.
Again the order.
Again the order.
এই উকিল বাবুকে এই ভদ্রলোককে দেখাও, মিস্টার আগরওয়ালকে দেখাও, এইটার কপি উকিল বাবুকে দিতে বলো।
He understands, Milord. I'm sure, Milord. He understands.
দেখাও পুরো সেটটার কপি দিতে বলো। এই কপিটা আছে ফাইলে?
No, presently I have not.
Let it be submitted.
আসুন,
Allow us to
দিন।
contact.
The parties are represented. No, the writ petition is present in person. Stop. On behalf of the alleged contemptor, it is submitted. Good name, sir?
Dilotpal Chatterjee.
Yes, sorry. It is submitted by Mr. Chatterjee.
In terms of your Lordship's last order, Lord, may I file the report? The exception of this report not yet been served upon.
এই ওটা দাও, মিস্টার গাঙ্গুলি কি দিচ্ছেন?
My lord, on 13th June, we have received the report, and we are also filing the exception to the report, my lord.
But I haven't got the copy of
My
the
lord,
exception. Let
I'm
me have the
serving-
copy of the exception.
I'm
I'll
serving the
go
copy
through
of
it and I'll make my submission accordingly.
আসুন, the report and exception to the report as filed by the respondent state
তোমার কথাটা বলে দাও এটা আমি বলবো।
So I appear on behalf of.
This for the petitioner.
And for the state, my lord, led by Mr. Terry Yusuf.
Mr. Anirban Da. None appears on behalf of the writ petitioner. Though learned advocate for the respondent state and learned advocate for the petitioner.
My lord, I beg to appear for the petitioner.
File the
1 to 7.
My lord, at the outset, permits me to file the affidavit of service. My lord. My lord, at the outset, my lord, kindly comes to page 12 and 13, which is, my lord, the land record of the petitioners, that we are the Rayati landowner of our property.
12 and 13 are the record of right.
My lord,
In the name of
Page
Poritos
12,
Bera
page 12
and
and 13.
Nandotulal
Nandodulal Bera.
Bera. Very
These
good.
two, my lord, are the petitioners.
Yes.
Now, my lord, just in front of my premises, my lord, certain illegal constructions have come up, which is, my lord, a road maintained by the PWD.
Very good. At the instance of the
At the instance of the private respondents, my lord.
8, 9 and 10.
My lord,
8, 9 and 10 are
and
represented.
my lord, 8, 9 and 10.
Yes, sir.
Thereafter, my lord, I have sent my representations to several authorities, which is, my lord, starting from page number 14. First, starting from the DM, thereafter, my lord, the relevant authorities, my lord, the executing officer of PWD and assistant engineer of the PWD. These two, my lord, will find at page number 15 and 16. I have also served the similar
Who
representation.
will consider? Respondent number 5 will consider.
My lord, respondent number 5. Respondent number 5.
Mr. Banerjee, have you got any report?
They have claimed, my lord, relief under 2 acts. Kindly comes to page 16 once, my lord.
Be that as it may, sir.
There is,
Nomenclature or
my lord, there
If it
is
if it
there
is
is
a
a
government
reason
land-
behind that. There is a reason behind that. My lord.
If it is government land, then my lord, public land eviction of unauthorized occupant tax shall apply. If it is a road, then my lord, the highway tax shall apply. So let the assistant engineer decide. Not if it is within his domain, he will take steps. Consider.
My lord, I being a layman, I am not aware of the fact that whether the particular road has been declared, notified as highway, state highway or not.
Then he will
As my
ascertain that.
learned senior friends ascertain that if it is a highway, then it will come under Highways Act, otherwise public.
আচ্ছা উকিল ও শোনা ওনাকে শোনা হয়নি বসো। Of course, of course. আসুন। At the time of Who is for the petitioner? The petitioners are not represented today.
But 12 and
Item
13
12
are
and 13 are identical matters, my lord. There are 4 matters filed on same cause of action. The property relates to Mongla Hut. It's a
What the-
large valuable property.
Monglahat matters have,
You, Her Lordship, have passed one order in one matter.
when those matters are fixed.
My lord, that has been fixed on. Kindly have a look to the order.
18 July.
18th. 18th,
Let
your
these two
lordship.
matters be also fixed
But
on
the
that.
same order may be reimposed on this because that was filed by one of the plaintiff of the said suit. I am the owners of the property, defendant number 7 and 8. That is in whose favor the registered deed stands. Kindly, your lordship may recollect, my lord, there exists order of injunction
কি আছে দেখি
over
একবার।
the subject property by an order of High Court and Supreme
down
Court.
Let's same order be.
This, my Lord Justice Sanjeev Banerjee's division bench passed an order that I will not create third party interest. This order was affirmed by Supreme Court and SLP is pending. Page 81 is the order passed by my Lord Justice Sanjeev Banerjee's division bench in connection with an appeal. Your Lordship will find, my Lord, this is appeal by Mongla Hut Construction in suit of Mimani. That was the writ petition filed by the plaintiff, in which your lordship have passed this order restricting state from making any construction and entering upon the property. Therefore, I am defendant number 7 and 8 in the said suit. That means that in that suit, they have, I'm sorry. No. Answer. না 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 সেম একটুখানি শুধু ওনারের রিট বলে সেম হবে না সেম অর্ডারটা ওতে পাস হয়ে এক থাক যেহেতু ওর প্লেন্টিফ আমি ডিফেন্ডেড হ্যাঁ কিন্তু ওরটাও প্লেন্টিফ আমি ডিফেন্ডেড সেই জন্য সেম অর্ডারটা থাক আলাদা সিরিয়ালে থাকে না একই সঙ্গে why I am
What is your
page 59 kindly have a look to this Milord. Why I am submitting this Gopidas Memani is the writ petitioner in
59?
Yes, page 59 of the.
Yes.
Now your lordship will find the plaintiff is Gopidas Memani.
Hmm.
In the writ petition in which your lordship have passed the order is on a writ petition filed by this plaintiff, that is Gopinath Memani.
Yes.
I am, my lord, defendant number 7 and 8. Kindly have a look to page 62. I am Mangla Hut and Gajanand Agency. They have filed this suit over the subject property, praying for setting aside registered sale deed executed in favor of Mangla Hut and Gajanand. Therefore, in pursuance of
No, in so far as Gopidas Miami is concerned, I think it is the case of the writ petitioner that they were the purchaser of the property.
No, my lord.
No, a specific purpose of
Yes,
contract
yes,
was-
yes. I am the purchaser. They say that my decree passed in the suit before this honorable court, in pursuance whereof the registered deed were executed in favor of Manglahat and Gajanan, according to them, is fraudulent. This is the copy of plain. May I just read? Page 87.
No, the petitioners in the earlier round of litigation,
is a plaintiff in this suit. And
he has
the prayer
filed a suit for specific purpose of contract.
My lord, may kindly have a look to the relief. This was
And
a
another
rare
suit
petition.
before the original side for avoiding a collusive
Your
deal.
lordship may recollect, my lord, looking to it. This is the prayer. Kindly, this will make once clear, my lord. Kindly have a look to the prayer made in the suit. They want cancellation of the decree passed in my favor by this court. Further, they seek cancellation of registered deed in my favor. That suit is pending. This is the suit, my lord. I have obtained a read petition from Sarthak. This is the relief claimed in this suit. This is against defendant number 6, 7, and 8. 7 and 8 are the purchasers by virtue of the decree passed by this court. And 7 and 8 are petitioners in this writ petition, 12 and 13.
Gopidas Miyami is the defendant in that suit.
No, plaintiff. He has filed the suit against me to set aside decree passed in the suit.
So against you means that you are dependent.
Yes, yes.
Then why
I am defendant number 7 and 8 in their suit.
in their suit?
Yes. 7 and 8.
As per the degree, you are the owner of the property.
Yes, my lord. I am the owner of
a coordinate bench of the original bench passed a degree of your declaration
in my favor.
on the basis of your deed of title.
Yes, yes. I got a
which they want to avoid by filing a subsequent
suit. They have filed the suit challenging that decree and my
Understand.
deed.
Now, what is your
Now, page 81. Your lordship may kindly look to page 81. This is the order passed by the division bench of this high court in that suit, whereby an order of injunction was passed restraining me, defendant number 7 and 8, from transferring the suit property. I have been page 81. This is the order passed by my lord, the division bench.
What is the relevant part?
The relevant part, your lordship will find, my lord, that this has not interfered with the impugned order, and the relevant is page 83. The other order, that part is only, your lordship would recollect, my lord, that on that date it was placed by Mr. Thakkar. Your lordship also inquired about that. The other order challenged is July 25, 2018, by which defendants were restrained from collecting any occupational charges from the occupant of the market at Manglahat, and a special officer was appointed to inspect and make inventory in premises B to the application. And
this is talking about their suit.
Yes, yes. An order of
the persons who have filed for specific purpose of contract.
Yes, in their suit they sought for an injunction that during pendency of suit I should not create third party interest. The court, my lord, made absolute that order.
Where will get that?
My lord, that was by my lord Justice Sen, Justice Somen Sen. That your lordship will get it in the first, my lord, I have annexed, page 78. The interim order was confirmed. Page 78. In spite of service of defendant number 9, on February 5, 2018, I disposed of GA number 3707 of 2016 by confirming order dated 13 November 2017 in terms of prayer A of notice of mason.
So your clients have been injuncted
from making third party interest.
Very good.
This part stands still today. I have been injuncted.
That has not been interfered with.
No, no.
Neither
That
by
has
the
not been
division bench nor by
interfered
the
by
Supreme
division bench, not by Supreme Court.
Very good. Then what happens?
My lord, the next is the order of the Supreme Court, page 86. 3 SLP were filed before the Supreme Court against the order passed by division bench. These 3 SLPs are pending as of today. The first one is by Manglahat, and Supreme Court, my lord, modified this order. The SLPs are pending only to the extent that though there will be injunction not to make third party interest, but the special officer will not disburse 50-50 in favor of Monglahat and Gajanan. Only with regard to disbursement by special officer, the Supreme Court made stay, page 87. There shall be an ad interim stay of operation of modification of order dated 25/7/2018. This modification relates to only handing over whatever is collected to the owners 50-50.
Your clients.
Therefore, my client now
50 means 50 to you and
50-50
50
of the what special officer would be collecting from the stallholders
amongst whom?
to Manglahat and Gajana, defendant number 6 and 7. Defendant, that means I have been mellowed with the modification. Now
Gajanan is the vendor.
Gajanan is the purchaser. Manglahat and Gajanan are purchaser, now owners of the property in 50-50. 168 kata.
If
4 days.
Gajanan is the purchaser, then how do you represent then what is the stand of the Gopidas?
My lord, Gopidas claims, may I just indicate, Gopidas claims that he has an agreement, oral contract. On the basis of an oral contract,
Oh, so
he has filed the suit.
I'm sorry. So far as the who is the purchaser?
Purchaser are Manglahat and Gajanan.
Gajan. You are applying for Gajanan.
Yes.
But now what is your grievance in the instant writ petition?
Now, my lord, this instant writ application has been filed. My lord, the other writ petition was taken out by the plaintiff, in which your lordship has passed this order.
Yes, yes.
Therefore, the property is under my possession, and I have been injuncted both by High Court and Supreme Court not to create third party interest.
Though your title has been fortified by a degree of declaration.
Yes. Decree of High Court, registered sale deed, only it is subject matter of challenge in the suit filed by Mimanis. Injunction prevails by division bench and High Court.
What is your grievance in the
Now the
instant writ
grievance
petition?
has come in that in 2023, one day, my lord, a fire broke out at part of the property. Now, taking advantage of this fire, the state intended to intrude by soil test and by declaring that they will make construction. Your lordship has already restrained the respondent from making any construction. Therefore, since that writ petition is at the behest of plaintiff, who claims to be oral contract, and mine one is the, my lord, the owners of the property, therefore, your lordship will grant injunction from in the same manner. Let the matter be listed on the same days, because that is with regard to an interstate dispute, whether he has a oral contract or not. But he filed the writ petition, my lord, there were 4 in numbers. It was pointed out to your lordship. Your lordship said that one I am entertaining, the other will be follow the same order. Therefore, your lordship has directed there should be restraining the authorities from entering and making construction.
Lordship will record one submission.
Yes. And in my also paper cutting is there.
Lordship,
Yes.
Lordship will
Paper cutting
record the maintainability. We are disputing the
Paper
maintainability.
cutting is here also, page 95, same cause of action. My property taking advantage of that small fire, they intended to enter into and make construction. Your lordship has already stated that they will not be entitled to make construction. Let it be decided along with all, in all writ petitions. Let it be placed on same date, that is 18th July, with same order.
We take the maintainability point.
Please.
I have just
Whether
30 seconds submission.
whether read can be maintained.
Give me a second, sir. I'll hear it, sir. Wait.
Yes.
Read is not maintained. Kindly record this. Let us come. We'll argue on that. ডিরেকশন হয়ে আছে একটা ম্যাটার কিন্তু কেউ কিছু বললেন না কিছু
Yes,
Same order. may
I
be
understand.
passed and
What
it
is your
can be
contention? Maintainability of the disposition. Yes, sir. You are appearing.
Disputed questions of fact, read court should not.
Let their affidavits taking all point. There has been no notification and Supreme Court has already
On
cancelled the
careful,
notification.
allow me to pass order, sir. On careful consideration of the entire materials as placed
Yes, sir. Well, affidavit of service. Not sir, it was supplemented. And it was affidavit of service. Your lordship's court was pleased to direct to consider. While considering, my lord, the authority directed that you measure the property by the LMF.
Give me a second, sir.
My lord, I take the supplementary affidavit to see the impugned order. That was ineligible, that's why it has been. Taken out.
Which order is under challenge?
The order, but not dated. It's 57.
28/4/2025.
57.
28/4/2025.
My lord. Can you see the supplementary affidavit because one page is missing here.
Page number?
Page number 56, 57.
Of the supplementary bill.
No, only one annex supplementary.
You are referring to the supplementary affidavit or the need petition?
If petition, the impugned order is one page is missing. That's why can you produce the supplementary affidavit. Page 9.
Page number?
Page 9. Page 9.
এটা কি রাখো না এখানে all the parties are represented.
Yes, yes. ওই অর্ডারটাই তোদের অর্ডার অর্ডারটা দেখ নোট দিয়ে
Yes, sir. Kindly please.
Well, kindly see an appeal case number such as not necessary. Kindly come to third. Whereas on perusal of the said joint inspection report, the following.
It is an appeal under which act?
This is appeal. The appeal number under Highways Act.
West Bengal Highways Act.
Highways.
10/4.
Yes. 10.
Yes.
Kindly come to the bottom. The inspection has been conducted on the basis of the LR Mauja map. Kindly pause there for a moment. Here the direction was in the notice. Your lordship kindly come to page 54. That was done 54. Your lordship will understand.
Whereas on perusal of the joint inspection report, the following facts appeared.
No.
The inspection has been conducted on the basis of LR Mauja.
That is the
As per LR Mauja, the enclosures have encroached the Rasta and non-Juri.
But now, my lord, kindly come to page 54. 54 is a notice, copy forwarded to the special land acquisition officer. Item number 3 in the bottom, copy forwarded to. Land special officer with a request to send one surveyor with LA map. Because the part of the property was under the land acquisition proceeding. So LA map is the guiding factor.
The request to send
Yes, one surveyor with LA map.
DLR also is our land account.
My first one. Inter exercise is futile.
Why futile?
Because LA map will depict how much has been acquired, how much is left out. LR map will not depict that.
Then why the Highways Act will apply?
The allegation is we have encroached highways.
Very good.
Part of the highway when it was constructed it was acquired.
No, BLR has make the make a any demarcation report.
That is on the basis of LR.
Huh?
LR cannot. And my second point
The
is that
inspection has been conducted on the basis of LR Mauja
LR.
map. As per LR Mauja map, the encroachers have encroached
cannot be done.
the Rasta.
Cannot be done. Unless the LA map is there, which person has been acquired, which person is not. After acquisition, it become POS. Am I clear to my land was private land. Acquired. After acquisition, it became the government land part.
It vested to the state.
POS.
It should have been recorded in Khotiar number 1.
Yes, that's why LA map is necessary. And that's the direction. While considering the case, it was directed that you produce the LA map. And rightly said. This is the first point. Second point is, my lord, for the interim order, that the report has not been furnished by relied upon. I am relying on Supreme Court judgment for this.
No, show me why the so 10-3 proceeding was conducted.
Yes.
Where is that? I want to see that.
That is more. Kindly come.
No, that is to be looked into.
Kindly look at this.
Page number.
কোনটা কোনটা কোনটা
36 page is it?
কোনটা পিছু
48. Page number P6 is the page number
Just a minute,
48.
my lord. Page 48. Page 48.
I will give you a chance. Mr. Basu, come to the first, second, third, and fourth paragraph. Kindly place that.
Fourth paragraph.
Heard them. Page number 48 of your read petition.
Yes, my lord. My lord is asking me to first, second, third, fourth. Considering.
Heard them.
Heard them.
Yes.
Here are report received. Right, memo number such and such. Such and such, such and such. This report was never furnished to us.
Kindly peruse, sir. Kindly place, sir.
Received memo number such and such. Clearly establish the unauthorized encroachment of the government land under PWD plot number such and such, near such and such, more to Panchayat over Sodipur. It is also admitted by the encroachers. What is that, sir?
So before that authority, have you raised the point
Which one, my lord?
that you have been provided with?
Cannot, because after they decide, I cannot go there. Then we approach your lordship's court.
No, sir.
Kindly come to the next.
No, sir, I don't go. So far, 10-3 proceeding is done. It has been
Relied on
conducted.
a report.
Mr. Basu, try to listen to me. So far, 10-3 proceeding is concerned. Is the jurisdictional subdivisional magistrate conducted the proceeding? Your clients appeared there?
Yes.
Have you taken the point before the subdivisional magistrate in a proceeding under section 10(3) that prior to passing of the order, please provide me a copy of the report?
I don't know. After I get the order, I find a report has been provided.
Very good.
Now, my lord.
In your in your memo appeal, have you taken that point?
This stage gone. Thereafter, I approach your lordship's court. Kindly come to page 50. What is the direction?
Against the 10(3).
Yes, that's the order. Against that we have come.
Page number 48 হলো এটা।
Page 50.
Yes, sir.
Yes, kindly come to the concluding portion. In view of the above, Disposition number 9, upon issuing a prior notice to the petitioner, that is the notice I have shown to you, lords, shall cause a physical inspection of the alleged encroachment as mentioned in the said improved notice, which is such and such, to the writ petition, and shall file a report with the proper sketch map if there is any encroachment. Copy of the report shall be submitted to the petitioner also. The exercise shall be carried out with such and such time.
It is prior to 10(3).
After 10.
Huh?
That's why I said 10 gone. After 10,
If 10(3) gone, then how do you prepare an appeal?
Appeal was pending there. That's the direction of the court. If that is your lordship's observation, then my lord, this appeal is not a waste.
এটা কবে হয়েছে? 24/7/2024. Just a minute.
After this order, my lord, this exercise has been conducted by the appellate authority.
24/7.
So I presume, my lord, this point was taking that notice, the report has not been served. That's why court directed to submit it.
24/7. This order was passed on 9/12. What order has been passed?
Internal page 2 will suffice, I think.
March 20. Mr. Basu, I think that you are not properly briefed, sir. Kindly come to page number 50, paragraph
yes.
number 4.
Yes.
The
Paragraph?
impugned order is March 20, 2024.
Yes.
And here you are referring to 24 July 2024.
But whatever may be, whatever may be,
Situation is changed, Mr. Basu.
that has been, Reed Court has decided that. Reed Court has decided and come to a conclusion that you exercise afresh.
While passing final order in the earlier round of litigation, the Reed Court, a coordinate bench of this court, practically set aside the order dated 20th March 2024 as passed in connection with the 10th proceeding. Am I correct, Mr. Basu?
Yes.
Thereafter,
This
rightly
direction
or
was-
wrongly, 24th July 2024 order was passed again in a 10th proceeding, which is subject matter of challenge in the instant appeal.
Right.
The appeal has been disposed of.
Appeal has been disposed of by I have 2 points. Deciding that court and the notice also decided that you rely on LMF. Why? There was acquisition proceeding. LMI will depict.
BLRO, it has been clear-cut finding of that.
Finding
The
will not-
inspector LR Mouja, on the basis of the LR Mouja map.
LR Mouja will not do. Well, kindly apply your lordship's old experience. While LR map is for the purpose of acquisition, here the property was acquired. If property is acquired, this property was private property. This property was private property. It was acquired.
I
So
understand what you intend to say.
must be with an LMF. LMI will depict, my lord, which portion is acquired, which portion not. If under the basis of LMF it finds that I am encroaching the land which has been acquired by the state, I will know her.
Where is that order? Where is that order?
Which order, my lord?
What is that letter you just referred?
Yes.
Regarding
It
LMF?
is that page 54. This is the notice
54, no?
for joint inspection. 54.
Hey, Ashun.
Three. And my
I've
second
seen.
point is, my lord, the notice, my lord, the document relied upon has not been served. I'm relying on, my lord, 1991.
In that point?
This is a question of law. This is a question of law.
File din, file.
My lord, kindly see. My lord, kindly see the 27, my lord, he has already rejected this application. My lord, kindly see the item number 14, my lord. 25, he has not annexed this order, my lord.
Let me see what is there. What is that? Let me see what is that.
He has filed this implementation, this order of the DM, my lord. Already he has annexed this order, my lord. He is suppressed on this fact, my lord.
Very good. Let him. You are a party.
No, he has not party. My lord,
No,
my lord,
as we can
earlier
remember,
interpretation I have
he-
annexed,
he-
my lord.
my lord, 10-3, 10
Correct.
code, he is determined that he is the encroacher. He has no locus. That's why I am not made a party.
My lord, kindly see the page 27 of the earlier
It is
interpretation, my lord.
point number 7 to comply with the order dated 25/2020. ভাই আগের ফাইলটা একটু দেখতো বাবা।
Yes.
25/2025 is the is enclosed.
Yeah, he has enclosed.
yes.
He has not
I have
enclosed.
enclosed.
Ah.
And you logically
Page, my lord, kindly page 27.
Sir, all not all at a time.
page,
Sir.
page 41.
ওরা আসো এখানে।
Page 27, my lord, kindly see the earlier interpretation. He has not annexed this original order.
হ্যাঁ
Page 27, my lord, application on 11523, my lord.
কে এটা রিজেক্ট করলো?
এটা তো SDO।
এসডিও কেন রিজেক্ট করবে?
আরে
এসডিও রিজেক্ট
তোমার
আরে তোমার 10 ফিজে তোমার তো
বলতে
রিজেক্ট
দিন
হয়ে গেছে।
মানে দাঁড়ান না, মানে kindly see the page.
No, not now. It is his petition. His right of audience.
He has no locus. মানে 10 your logical issue 25/2025.
হ্যাঁ
Hello, order passed by the district magistrate. Page 41. And ordering portion is page 28/4/2025. Next page.
you want the implementation that of that order?
Yes.
Huh?
That implementation of that order.
Come to page number 10. এটা আবার কোথা থেকে এলো? ওইটা দেখি গো, এই আগের ফাইলটা তো আবার দেখি। Kindly come to prayer B. What is that order?
Order dated 2/5/2025.
What is that order?
It is the communication.
Huh?
It is wrongly typed out, my lord.
মানে
At 28/4/2025.
Can you come to page 40? Second,
That I've seen.
that is the air communication. This is the communication of the magistrate to all concerned, along with the party.
Yes, my lord, that later, my lord, I have
And why page number?
page 41.
Page number 41 is the order.
Communication, all communication. Page 42 is the ordering portion.
কোথায় communication রে ভাই? Page number 40.
Page 41. After passing this order, district magistrate communicate this order to all concerned.
পেজ নাম্বার এইগুলো ওকে দেখো, আমি তো বুঝতে পারছি না পেজ নাম্বার 41টা কোথায় কমিউনিকেশন অর্ডার তো দেখাচ্ছে।
Page 5, P5.
দেখাতে বলুন পেজ নাম্বার 41 আমি মনে হয় I believe there must be some communication gap. How do I do, sir?
আমি বলছি আমার
কি সব করে এরা? So by this letter, that order was communicated. DM, district magistrate order was communicated. Now you tell me what is the difficulty? No, in the earlier round of, in the earlier petition, I have upheld their order.
Order passed by Calcutta Magistrate was 9/1/2024. He has not annexed, my lord. Kindly see the order, my lord.
Not required.
And after that, my lord,
Well, kindly see the order.
No requirement to see
Well,
that.
he has not- he has suppressed, my lord.
Very good.
what submission? Suppression. Final order pass হয়েছে কবে? That order I have annexed.
Mr. Dhar, actually SDM's order is to be implemented.
Yes.
Hmm.
Kindly take the second reference. Now,
First one,
second reference.
earlier one.
No, second one.
This one is here.
Yes. In that reference, my lord, kindly, I don't know what is the page in my lord's file. The order dated, order number 2, then and dated 28th April 2025. My lord must be on that. On top, my lord will find an appeal case number 2 of 2024 challenging the order dated 24th July 2020 passed by the SDM.
So that order is to be implemented.
My learned friend is mixing up things because SDM previous order is 28. Of this case number 24. Now, my lord, in the same writ petition, my lord, kindly come to the next proceedings, that is miss case number 16 at page 48. My lord, kindly come to page 48. Previous writ petition. First writ petition.
This case number?
Miss case number 16 oblique capital A 2024.
Page number?
Page number 48. Two different miscellaneous
This case 16A,
16A,
which has been affirmed.
which this 16A went up to appeal, which has been affirmed, as my lord said. In
By 28 for order.
by 28/4/2025 order. So, this case number
This case number.
24 A 2023 at page 27. এটা তারপরে কি হলো? এটার পেটটা কি হলো?
আরে দেখো না, এটা তো দেখাই যে ওইটাই তো কন্টিনিউশন নিয়ে ওই অর্ডারটা পাস হচ্ছে। তারপরেই তো ওদের যেটা
এই অর্ডারটা তুমি চ্যালেঞ্জ করলে?
আমি কেন করে দিয়েছি?
সেটা নিয়ে বলছি না, দুটো আলাদা দুটো মিস কেস, এটাই তো আমি বলেছি।
তারপরে গিয়ে ওইটা কনক্লুশন এইটা তো সাবমিশন। এই ওইটা যেটা করে অর্ডারের পোর্শনটা দেখতে, হ্যাঁ দেখেন
kindly come to page 28 of this case 24. It means page 27.
Just a minute, sir. Yes, sir.
On page 28, my lord is on page 28.
Previous read petition.
Previous reading.
Page number 28.
28. In page 27, at last penultimate paragraph, before penultimate paragraph, so it is clear that the question of total obstruction of ingress egress of the petitioner does not arise of the above clause. Again, in case of plot number, the petitioner is in possession and also a recorded holder as per report of ELLR such and such. But ordering portion, Manor kindly turn to the next page, which is at page 28. Hence, Manor has got hence, considering all the above mentioned facts, this ordering portion says all the 14 encroachers, number of encroachers, described below have to remove encroachments from the aforesaid government land. That has got it. Number one. So in a way, effectively,
10-3 was there.
yes, they are encroachers.
10-3. So it is the order dated 20th March.
20th March in respect of Miss case number
Now,
24A.
now, this appeal was preferred against which order?
Appeal was preferred against 16A, Miss case number 16A of kindly come to 20th April 2025. So
16A, yes. So this order, 16A order is to be implemented.
yes, 16A order.
That's what I am saying.
No, my job is
Thank you very much.
No, no, that or
Only there is a postal tag report.
it is established that
ঠিক আছে চলো চলো আমি বুঝে গেছি চলো কি লেগে Anything more? Why? আজকে একটা ছিল না সকালবেলায় আপলোড করার ব্যাপার ছিল। তোমার কাছে ওটা চলে যাচ্ছে, যাবে ওই নিয়ে যাচ্ছে।
Of the Honorable Division Bench's order in Can 20. That was the last thing I placed, my lord. I placed paragraph
File.
70.
WPA 26090.
Right.
Flag दिया।
And I was placing, my lord, paragraph 17.
Yes, sir.
My lord, where the Honorable Division Bench, while taking into consideration Can 20, categorically recorded that, my lord, 5 lines from the top of that paragraph, we feel 5 or 6 lines, we feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as by the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared, indicating the successful candidates. Now, my lord, this being the clear direction made by the Honorable Division Bench, there was no
Yes.
there was no room for any further interpretation. You know, one view is that, my lords pass orders. The orders may be without there being any judicial verdict. A clear direction may be interpreted in some way or the other by a statutory authority that may give rise to an independent cause of action. But, my lord, when the Honorable Division Bench intended that no further written test is to be required, to be conducted, my lord, then in furtherance to the Honorable Division Bench's pronouncement, my lord, page 49, upon being issued, has planned to complete the recruitment process. My lord, this plan to complete the recruitment process, my lord, squarely it has to relate back to the orders referred to here. My lord, till such time, till page 49, there was no difficulty. Page 50, no difficulty.
So, Mr. Bhattacharya, I believe it would be your contention that on perusal of paragraph number 17 of page number 47 of the instant writ petition, your interpretation is that in practically in black and white, the division bench did not permit the commission to take further written test
And if that
in
is
connection with the subsame recruitment process. And your second, I believe your second point of submission is that proper interpretation of the notice dated 30th July 2024 as published by the commission clearly indicates that their plan of action is to comply with the said order of the division.
now, yes, I'm grateful. Now, my lord, while doing so, up to the 4th of August stage, they did not create any problem. The problem cropped up the moment, my lord, they sought to issue 5th of August 2024. That is the new examination. My lord, my first humble submission to your lordship is this is in clear breach of the Honorable Division Bench's order. And the action is contumacious in nature. It is a clear case of contempt of the Honorable Division Bench's order. Irrespective of anything, the Secretary Madrasa Service Commission or whoever the authority is.
That is why I asked Mr. Mr.
Mujumdar.
Mr. Mujumdar, Mr. Somu Mujumdar, whether before the division bench in connection with that there's a mandamus appeal, any subsequent application was preferred by the commission expressing their intention to hold further examination.
No.
The
With respect,
answer of Mr. Mujumdar was no.
Because, my lord, the last application was Can 20.
Very good, sir. I understand. Come to the next.
So my humble submission, they are in breach and their action is in contempt. They are in contempt of the Honorable Division Bench's order. Clear contempt. They are in interpreting a Honorable Court's order. If the authorities choose to act in a particular direction, that may give rise to a fresh cause of action. That may. There are judgments to that effect. But, my lord, if there is a clear breach, my lord, I could have understood that something was left open for the commission's discretion. In paragraph 17, when it is clearly recorded that we are unable to comprehend the stand of
the don't repeat this.
So that if it is clearly recorded, that is a clear rejection of their application to conduct a fresh selection, and therefore any step in furtherance to such direction is a nullity, is ex specie illegal. Then, Lord, coming back to the comprehensive affidavit.
Comprehensive affidavit din bhai. কম্প্রিহেন্সিভ এফিডেভিটটা বার করে দিলেই তো আপনি সব শুধু তুলে দিচ্ছেন গো। ওটা দিলেই তো হয়ে যাবে আমার।
হ্যাঁ 26090.
Yes, Mr. Bhattacharya.
My lord, one of the writ petitions which has now been assigned to your lordship, my lord, serial number 44 of the days list, Hafizul Hawk 21918 of 24. One of the writ petitions. Now in
Again assigned.
no, it is assigned. It is already appearing. Item number 44. It is
It has
in the
been
bunch.
tagged. It has been
Yes,
tagged.
yes, it is bunched in the bunch.
Very good. Then
Now, my lord, in that writ petition, an order was passed by a coordinate bench of your lordship's court, which is appended to the affidavit, my lord, the comprehensive affidavit. Please come to
Justice Sinha's order.
yes, just my lord, page 188. I would request my lord to straightway come to 189. Please come to page 189.
Yes, sir.
Now, please see paragraph 5. It was further observed that the bench is unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the honorable bench as well as the honorable division bench. So, this order was not appealed against. This was accepted.
No, a prayer for modification has been.
Nothing. Not
No, against this order, a prayer for modification is there.
yes, prayer for modification. That was withdrawn. That was withdrawn at the instance of the commission, I am informed.
Be there as it may, I have seen that one application is pending for modification or for interpreting some. Yes.
But Can 4 was filed by commission.
Can 4 was filed by the commission. It was apparently withdrawn, I am told.
Very good. No
I mean,
appeal
not-
preferred. No appeal preferred.
No appeal. And my lord, they have also placed reliance on page 148. So they are conscious about whatever they are seeking to do. 148 is an order made in connection with Can 19, filed in connection with the appeal. Page 148 of the comprehensive affidavit. 148. This is Can 19. In Can 19, my lord, apart from anything else, they were seeking for extension. Please come to 150.
Yes.
Please see the bottom. At the time of hearing of the instant application, several other issues are raised by the appellants impinging upon the merit of the order of the single bench as well as the appellate court. It is submitted that subsequently certain illegalities and irregularities have been detected, and therefore the court should reopen the entire issue, but till date no application has been taken out. And the only application which is pending before us is the extension of time to complete the exercise. So, taking recourse, taking shelter from this order, Can 20 was filed. And Can 20, there is an express rejection in paragraph 17. So, my lord, in a nutshell, my entire submission boils down to only this issue. The entire endeavor of the commission to hold a fresh examination is a nullity in law.
It's contrary to the direction passed by the division.
Yes, but I am not even saying that it's a nullity. It's especially illegal
On account of the
division bench.
Violation of
Because, my lord, it is not an implied rejection. It is an express rejection to hold the examination or a re-examination or a further written test.
Very good.
Now, my lord, in the light of this, only two things I want to say. Assuming assuming but not conceding that whatever they have done is correct. In that event, two sets of candidates are not on the level playing field. One set of candidates are being subjected to one examination procedure or one examination, one question, one set of questions, and the other.
Samim argued yesterday
Yes.
on that.
Now, Milord, to that, Milord, I just want to supplement. Milord, this is in the
Actually, I asked this question.
yes.
Whether in a recruitment process, whether two sets of question papers can be, examination can be taken on two sets of
Milord, exactly what has fallen from my lord has been decided by the has been held by the Honorable Supreme Court in writ petition civil numbers 456/2025.
WP number.
Copy.
It is unreported or reported, sir?
Puro paper tulis ni. What are you doing? But I cannot cite this. I'll cite it tomorrow because this is incomplete.
You give me the citation, please.
It is
Unreported.
writ petition. Milord, it may be now reported in SCC online. Check could be Aditi and others. Aditi and others. That's all. Aditi and others. ADITI and others versus National Board of Examination in Medical Sciences and others. What rubbish is this, Golam? দাদা বলছি 7 পাতার my lord, I'll hand over of entire copy. না আপনাকে না দেখি এই মামলা হবেই না, আমি বেরিয়ে যাবো করতে। কপি দাও স্যারকে, কপি দে। এসএসসি অনলাইনে নেই?
This is the judgment of the Supreme Court.
Yes. In MBBS. Milord, in MBBS. Now, please come to straightway paragraph 10.
You give me a second, sir.
I'm sorry.
WP civil number.
Print করতে থাকা কাজটাকে যেটা এন্টারলি প্রিন্ট করতে পারবে।
56 2025.
চাঁদা ছয় নেই।
National
পাঠাচ্ছি, আমি পাঠাচ্ছি তোমাকে আমি পাঠাচ্ছি।
examination.
শুভজি পাঠিয়ে দিয়েছি। This is 2025 SCC online.
Give me a second, sir. Just a minute.
SC 1288. পাঠিয়ে দিয়েছি তোমার।
What is the SCC online?
2025 SCC online. ফাইনাল অর্ডারটা নেই। হ্যাঁ 7 পাতায়, ওইটাই 10 পাতা, ওইটাই। This is what the Honorable Supreme Court laid down in paragraph 10. Please see paragraph 10. Holding the examination in two shifts would invariably enable arbitrariness and would not entail at par evaluation of the comparative merit of the candidates who take the examinations. No two question papers can ever be said to be at an identical level of difficulty or ease. There is bound to be a variation. Normalization may be applied and adopted in exceptional circumstances, but not in a routine manner year after year, especially when the number of candidates is not unduly large, as is the case presently. Now, this is pertaining to the national eligibility cum entrance test. You know, the MBBS admission. And another, Milord.
Give me a second.
I'm sorry. কি বলছে পাশের জন্য আমার ইয়ে চলছে সকালবেলা চোখের সামনে বেরিয়ে চোখের সামনে ঠিক আছে তোমার কি আমার 500 টাকা নিয়ে নিয়েছে একেবারেই নিয়েছে কোনো শুনছে না শুনছেই না মেডিকেল কনস্ট্রাকশন মানে
This is Mr. Bhattacharya 2025 SCC online.
Yes.
Supreme Court 1288.
Fine. Fine. Milord, just another additional judgment, Milord. It is the principle I am trying to adopt, Milord. Though it is in respect of commercial transactions, in respect of tender matters, but Milord, the issue of level playing field has very succinctly been laid down by the Honorable Supreme Court in this reported judgment, Milord, 2007, volume 8 SCC, page 1.
2007 volume
8 SCC, page 1.
1.
Paragraph 36 in particular. Sir, 7-8 SCC, page 1, paragraph 36.
You have copy or will search?
Milord, I have given copy. Very good.
এইটা উকিল বাবুকে ফেরত দিয়ে দিন এটা ট্যাবটা
Milord, please see paragraph 36.
let the matter be placed first. পুরো মামলার নম্বরটা লিখে দেবে
First.
পিটিশন আনি লিখেছো নাম্বার yes thank you paragraph number 36 sir
Please see page 21.
paragraph number 36 yes sir
Milord, this is in the context of Article 19(1)(g) and read with Article 14. Milord, read with Article 21. Milord, kindly, for the present, Milord, 19(1)(g), right to trade, profession. Milord, ignore that part. We are concerned with Article 14, 16, and 21 here. What does it say? Standards applied by courts in judicial review must be justified by constitutional principles which
which portion you are reading
paragraph 36.
yes
Standards applied, Milord.
Yes,
We find
yes.
merits in the standards applied by courts in judicial review must be justified by constitutional principles which govern the proper exercise of public power in a democracy. Article 14 of the Constitution embodies the principle of non-discrimination.
However, it is not a freestanding provision. It has to be read in conjunction with rights conferred by other articles like Article 21 of the Constitution. The said Article 21 refers to right to life. It includes opportunity. Opportunity. I have a right to a fair treatment. I do not have a right to be selected, but I have a right to be considered for selection in a fair and transparent manner, and that opportunity flows from Article 21 of the Constitution. Then, my lord, in our view, as held in the latest judgment of such and such, Articles 29 bench, Articles 21/14 are the heart of the chapter on fundamental rights. My lord, we are also concerned with 21 and 14 here. It is the heart of the chapter of fundamental rights. My lord, it says they cover various aspects of life. Level playing field is an important concept while construing Article 19(1)(g) of the Constitution. My lord, just not in the context of our facts, it is Article 16. It is this doctrine which is invoked in the present case. When Article 19(1)(g) confers fundamental right to carry on business to a company, it is entitled to invoke the said doctrine of level playing field. We may clarify that this doctrine is, however, subject to public interest. In the world of globalization, competition is an important factor to be kept in mind. Just like a selection process, the doctrine of level playing field is an important doctrine which is embodied in Article 19(1)(g). This is because the said doctrine provides space within which equally placed competitors are allowed to bid so as to subserve the larger public interest. Instead of bid, participate here. Then today India has dismantled such and such. Kindly ignores that part. Then kindly comes to placitum E. Decisions or acts which result in unequal and discriminatory treatment would violate the doctrine of level playing field embodied in Article 19(1)(g). Time has come, therefore, to say that Article 14, which refers to principle of equality, should not be read as a standalone item, but it should be read in conjunction with Article 21, which embodies several aspects of life. There is one more aspect which needs to be mentioned in the matter of implementation of the aforestated doctrine of level playing field. Then one of the important factors. So what I am respectfully submitting, my lord, in the context of the previous Supreme Court, read with this, my lord, here your lordship is poised with a situation where two sets of candidates are being subjected to two different, my lord, sorts of treatment. My lord, in a nutshell, my lord, these are my submissions. My first submission, I lays very strong emphasis that the commission is in contempt of the Honorable Division Bench's order. The entire action is expressly illegal. Those are my submissions.
Anyone want to join
Yes, yes, yes.
on any new point? Yes, sir. Yes. Please supply a copy of this. Mr. Bhattacharya, supply a copy of the judgment of Aditi case.
Yes, yes.
My item number 45.
Case number, please.
Yes, number is WPA number 24789. 781 of 2024. Habib Mundu. MD Habib Mundu.
You are at par with Mr. Mojumdar, Mr. Samim, and Mr. Bhattacharya.
Yes, yes, yes. I heard their submissions. My all points are covered.
You are Mr.
Dibyendu Chatterjee.
Mr. Chatterjee. Dibyendu Chatterjee.
তুই জিজ্ঞেস করছিস সেটা? Oh.
He is Mr. Chatterjee and you are Mr. Chattopadhyay. Right? Two 4 7 8 1 দাও
781
এইগুলো সরাও এটা এই কম্পোজিটর আপনি এটা বারবার অ্যাপিয়ার রাখছে লাগাচ্ছেন এটা তো এই লিড কেসটাই থাকবে এটা সরাও এটা দরকার If you have got any additional point, just tell.
Just only my all points are covered by my senior friends.
Then why are
No. Only adding, my lord, the notification dated 5th August 2024 is issued in violation of the order of the division bench itself.
that have submitted?
Also violation in the rules itself. Rule 1718. There is a procedure of written examination and what was the procedure of the interview that is mentioned in the rule. None of the rule permitted the Madrasa board to conduct the written examination in piecemeal manner.
That is the argument of Mr. Shamim yesterday. No provision for multiple test.
Yes,
Mr. Shamim has taken that point.
they are acted in violation of the rules also. That's
Very good. So you adopted the argument of
yes,
Mr.
yes, absolutely.
Mr.
absolutely. All
Mojumdar,
points are
Mr.
covered.
Shamim and Mr. Bhattacharya.
Yes.
Very good. Anything more?
No.
Thank you very much.
And item number 49 also I am appearing for the petitioners. 49.
Kindly now
Yes,
tell me the number, sir.
WPA number 26792.
26792
of 2024.
of 2024. Mr. Dibyendu Chatterjee.
Obligement.
Adopted. Very good. ওটা লাগবে না একই নিয়ে নিয়েছেন next sir anyone want to join
But
or add
one CAN application I have mentioned yesterday, my lord, addition of party is pending, my lord.
CAN application what is CAN
But CAN 2, my lord, in item 47, my lord, Joyanto Sardar, my lord, for addition. One candidate only, my lord. 47. 26090.
Addition of party you are supporting the case of the petitioners you will be added as a pro forma respondents
Yes,
like in
yes,
other cases
yes,
I shall pass at
But
the time of rising please allow me please mention I shall consider yes sir you are appearing
In WP number
WPA
9578
9578 of
2025.
2025
Lord, I'll in brief, Lord, I'll
Mr.
place
Shamim
Ahmed.
give me a second you are also challenging the set to notices
Notices.
anything you want to add
Yes.
new thing
Now, Lord, I want to clarify a few facts and at least two judgments I want to cite back.
no anything on new on facts
Lord, I just want to clarify to show the conduct of the commission.
no, I will not restrict you Mr. Shamim what I'm on
I'll not waste your lordship's time, Lord.
I'm not on that sir what I'm on whether you want to add anything
Yes,
either on facts or on law then you submit otherwise
yes.
I've taken a note of it
Yes, Lord, I'll add something on facts and also law also. Lord, so far, Lord, the point of res judicata taken by everybody. I'll not, Lord, repeat. But only, Lord, I'll hand over a judgment. Lord.
division bench expressly permit
I'll not repeat.
they didn't allow them to hold the second time examination
Now, Lord, I'll place the order passed in 2018, Lord, by this honorable court, the first writ petition in respect of this selection process.
by this court
By this court.
during vacation bench
By Justice
in a vacation bench
by Justice Pratik Prakash Banerjee.
no there is a single bench order original single bench order
Single bench order.
তাহলে তো ওই প্রথম ফাইলটা দাও ওই লিড কেসটা দাও
Let's take
has that been annexed
comprehensive affidavit. This is annexed, Lord.
ও আছে কম্প্রিহেন্সিভ এফিডেভিটে বলছে না আছে এটা দাও page number
But at page Millet 94.
page number sir
94.
94
94.
But kindly take note of the date of the order. This order was passed on the second day, where there was a prior order. Direction upon the authority was to file a report, and the report was filed before the court. Court has recorded. The writ petition was filed. The context was because the commission
publication of the result by the commission.
Now, my lord, court has recorded the reason they have stated, because the commission cannot take different stand. Now, the reason they have stated, on instruction, the result of the test is yet to be published, as instruction has been sought for by the commission from the Minority Affairs.
From the government.
Government. Court has held, you don't require. So this is the reason for which the result was not published. Now they have come up with a different reason that they cannot.
Now what they are saying?
That they are saying that there was a technical errors for which weigh machines could not be determined.
No,
Actually,
that is according to the commission, that is the cause, or that is the cause for holding the second examination.
Yes, that is the cause.
How it
for
relates to the public non-publication of the first result.
The selection process is single. There is no different selection process. First selection process, there was a screening test to screen out the eligible candidates. And
I
no,
have come across.
No, my point is,
Mr. Ahmed, I have come across on my own during vacation. I have been made to come across by the members of the bar who have appeared on the yesterday and today. What I'm on, for the first time, when the when the Showman Malakar's case, the grievance of the writ petitioner was
non-publication
of the result on account of the result of the written examination
and consequent selection.
Be that as it may. Now that has been upheld by the division bench.
That's a different issue.
Of the division bench.
That's different issue altogether.
Now they have come forward with they have published two separate notices. Published, held second phase of examination.
For what?
For in respect of other candidates, which is under challenge before this court. Now, what do you want to say?
My point is, they have never, unless those candidates for whom the selection process now held could not have been completed, unless the entire candidates were tested. Now they are conducting this written test to test the other candidates. So that could be the reason for non-publication of the result. At least one of the reason. The screening test was held when? In 2010, 11. Now, if they now held this examination, then this is another reason for non-publication of result.
এটা ওটা এলো ওইটা সৌরভের অর্ডারটা এলো দিন
Am I clear, my lord? Now, my lord, the list of dates would reveal that it is their list of dates, my lord, that notification 2010 and this screening was done in 2011. And what specific pleadings was made in that writ petition for non-disclosure of reason also for withholding, and that's the reason, that's why the court directed them give me the reason for withholding the result, and thereafter they have taken the instruction and filed a report.
Lack of instruction from the government.
No, yes, lack of instruction.
Now they have come with a plea that
Different
some candidates, some successful candidates in the screening test were left out. They were not permitted to appear in the written examination.
And when?
In the year 2011. Now I want to take examination of those successful, alleged successful candidates.
And
that
this
reason was not assigned either to the single bench or to the division.
or to the division bench until 2023.
I understand, sir. Come to the next point.
Now, let to cut short, let kindly take some the order of Justice Sinha at page 189. I'll just refer the relevant part only.
Yes, sir.
Specific direction, paragraph 9. Madras, kindly see the dates first. This was passed on 25th November 2024, challenging the notice. Immediately the notice was published. Let this writ petition was filed challenging the notice itself. Now, let paragraph 9, specific order was passed by this honorable court. Madras Service Commission shall proceed to conclude the selection test of 2010 without taking any fresh written test. I am on this. In respect of any other candidates in terms of notice dates so and so. Therefore, there was a stay on the notice. Now, let there was no variation stay of this order.
So the written test was taken in violation of paragraph number 9.
And is nullity. Judgment only paragraph 28 and 29. This is 2010.
Give me a second, sir.
Yes.
I'm not so fast like you, sir.
I'm sorry.
You have to bear a slow judge. What can be done?
I'm sorry. Writ petition. Oh, acha.
Yes, sir.
It's compilation page 189.
Yes, sir.
Namlet, this is 2010 11 SCC page 557.
2010
11 SCC.
Volume 11 SCC.
Page 557.
557.
Paragraph 28 and 29.
Yes.
28 is the code.
You have the printout.
No, I have just. Oh, I'm sorry.
Hey, দাও ওগুলো দিচ্ছি যেটা দাও নম্বরটা দিয়ে দিও 24588 না 245 না 9578 no your case number is 9578
আমার এই আমার কেস নাম্বারটা কত
9578
9578 This court, while dealing with a similar issue, held that even a court in exercise of its inherent jurisdiction under section 151 CPC, in the event of coming to the conclusion that a breach of an order of restraint had taken place, may bring back the parties to the same position.
Para 28.
Para 28.
Given a court in
Well, you got it. As if the order of injunction has not been violated. In view of the above, it is evident that any order passed by any authority in spite of knowledge of an interim order of the court is of no consequence as it remains a nullity. Therefore, whatever examination they have conducted in violation of this order is nullity. There is no examination at all.
When that order was passed, the commission was represented.
Yes, ma'am. Can I simulate Mr. Kamlesh Bhattacharya, Mr. Prosenjit Mukherjee?
That's all. Anything more, Mr. Amin?
Lad, one point they have taken in the affidavit regarding maintainability of the writ petition. I'll just cite a judgment on that, lad, of our High Court Division Bench. This is 2019 1 CHN 310.
19
1 CHN 310.
Paragraph number?
That paragraph. Yes. Not 52.
Paragraph 52. Yes.
Disputes relating to selection and appointment invariably involve question as to who can challenge such process, when and on what grounds. Obviously, the beneficiary of the illegal act.
The writ petitioners of this petition are not successful candidates.
No. No.
In their 2011 selection process,
in the written test they qualify.
Then
in interview, no. I'm sorry, that yet to be published.
No. According to what is your instruction? So far as 2000, your 9578
they have participated up to interview.
No, they were
qualified in the test. Qualified in the written test. They have participated in the interview.
Interview was held pursuant to the subsequent to the notifications and the challenge.
Yes. So, up to that stage, they qualified.
So, for the sake of our argument, if the notices goes,
then nothing remains.
No, that is it. You remain as a successful candidate in the written examination. That I intend to do. Yes, sir.
Well, these judgments says that if there is an infraction, then even a
kindly place, sir.
Yes. Perfect. 52 from third line, public interest litigation in service matters is generally not maintainable, except in exceptional cases. More often than not, it is the person aggrieved by their non-selection, non-appointment and consequent selection appointment of others who seek to pursue their remedy in accordance with law would approach the court to have such process which they perceive to have been tainted and invalidated. If the challenge is nipped in the bud on the basis of the authorities cited, which lay down the law that having participated in the selection process without demur, the participating candidate forfeits his right to challenge the process, does it not sought to extend the immunity from judicial scrutiny to such selection process, even though the process might have been illegal? Our understanding of the law on the subject does not persuade us to hold that an unsuccessful aspirant for a post can never challenge a selection process after his participation therein. There could be cases where the selection committee selects a candidate who lacks essential eligibility criteria for appointment. As in the present case, how would the eligible candidates know that an ineligible candidate would be preferred to him? There could be a case where candidate is selected who had not applied within the last date of making application fixed in the advertisement. How would a candidate not selected know before his appearance before the board of selectors that the selectees had not applied within time? Take the case of a candidate who is selected by the board of selectors, one of whom is a close relative of a selected candidate, and such relationship is not made known to the other selectors. If the unsuccessful candidate does not have such vital information,
I believe your footing is not so bad as
no,
the honorable
not,
court
not
discussed.
this. Not this,
Because
but
you
they have taken in the
participated, you participated and found to be successful in the
up to the
2011
stage of
examination.
written test, yes.
And maybe on account of participation of the alleged successful candidates, on account of the second written examination, you have been left out.
Yes.
That is your, I believe here. Very good. What is your next point?
Namlet, this is page 99 of the compilation affidavit.
Composition, evidence of opposition.
Yes.
Page number
99, the order of the division bench. Only one line I'll show Namlet from page 100.
Yes.
Page 100, first, second, third paragraph. In the supplementary affidavit, the appellant has foregone all other grounds to challenge the initially made in the instant appeal.
What is this order?
This order, they have ultimately sought for time to publish the result. The challenge in the appeal. In Showman Malakar's case, they ultimately preferred appeal. They have taken so many grounds of challenge for non-publication of the result.
Ultimately, at the time of hearing, they
have foregone all
grounds.
Foregone all grounds. Once they have foregone all grounds, can they now change their stand? This is first part, Milad.
Yes, sir.
And the very next paragraph, they have added certain grounds for the delay they have caused, and says individual candidates have appeared in the examination and the examining appointed in this regard have not evaluated the answer script as yet because of the voluminous answer script to be evaluated by the examinees to be so appointed. The time limit in the impugn order is insufficient. So they add this ground, the reason.
It's for extension of time.
Right. For extension of time. But this is the reason for delay, and they sought for time because of this voluminous answer script. That is the only reason they have.
Reason for delay was getting not instruction from the government.
And now,
when the single bench passed a time-bound order, the commission found in themselves aggrieved, approached the division bench with many grounds. However, at the time of hearing, they had foregone the grounds of appeal and had chosen to confine their prayer for extension of time on this ground.
Namlad, my last submission, that there are some petitioners who have participated in the subsequent test, which was held in 2024, and they are claiming their rights over this participation. Now, all these writ petitioners must have applied in 2010 pursuant to that advertisement. The rules relating to this selection process, there is a provision that after screening, the commission will assign reason for rejection. Now, if these participants who has applied for
রুলটা দেখি, রুলটা কালকে দিয়েছিল, ফার্স্ট ফাইলে আছে দেখুন, ফার্স্ট ফাইলটাই আছে দেখুন, রুলটা দিয়েছিলেন। You are referring which rule, sir? Rule of
2010.
10.
Yes.
Rule number
13 millet. Though this is at primary stage of screening of application, at 2 stage the screening is there. Rule 13 clause 3, in case of rejection of any application, the cause of rejection should be stated against the application in the database to be displayed in the commission's website, so that any applicant may know the reason of rejection of her application. This is one.
This is with regard to the application.
Application. Now, the second part is clause rule 16. Rule 16 proviso. Rule 16 sub-rule 3 proviso. This is prior to written examination screening. I believe that in this process they have been excluded. Now, here also, provided that the commission may hold screening test before holding the written test, in case of number of candidates applicants in any category of the post is huge, particularly in case of selection of clerk and group D staff in the manner as commission may deem fit and proper. Now, this process was held in 2011. None of these writ petitioners who has now come after participating in 2024 selection test has never assailed the process, and that may have
how do they? The rule 13 talks about screening of application. Suppose any applicant has not pasted the photographs, rejected. Any application is not accompanied by the requisite amount of postal order bank draft, rejected. Any application is otherwise all right, it does not bear the signature of the applicant, rejected. So this is called screening.
Yes.
Now rule 16 says that the different stage of examination. Now in the event the commission finds that the number of candidates are huge, for the purpose of elimination, they will hold a screening test. So
that screening test was held.
So those candidates were supporting the act of the commission.
No.
Found themselves not successful in the screening test. So what is the wrong?
But these writ petitioners were found unsuccessful in the screening test. And we were qualified in the screening test and participated in the written test. Therefore, the cause of action for this writ petitioner arose in 2011.
Challenging their failure.
Yes. Yes. They could have. Because of the present policy which we have challenged, now they have
I cannot understand, sir. What is your contention, sir?
In 2011, all of them found unsuccessful in the screening test.
Sir, I failed in class 9. Subsequently, I was pursuing my study in class 9. Now, sir, subsequently, I have been informed by the West Bengal board that no, you have passed in class 9.
When?
Here,
After 15 years.
be the rest with me. Now, I have joined class 10 and appear in Madhyamik examination. So how can I, now I can challenge the process. How can I challenge that there of my failure at that time in class 9?
Like a person participated in the selection process. He was not qualified for the written test.
Their cause of action arose on account of their participation and publication of results in their paper
in 2024.
In 2024 exams.
Right.
So there lies the cause of action for filing those writ petitions, for implementing the result as published in such and such way. So where the cause of action arises?
My point is,
this cannot be accepted.
My point is that Commission has taken a policy decision in 2024 to.
That is subject matter of challenge, sir.
Subject matter of challenge. Now, these writ petitioners.
This court holds that the decision of the Commission for holding second phase of written examination is bad, is non-honest, is contrary to the directions of the single bench, division bench, even by the order of the coordinate bench. In a separate petition, the entire process will go. But how does it affect their right? Their
In one line, I can clarify that. This writ petitioner cannot say that the screening was bad. That the Commission can say because of their policy. Because writ petitioner never challenged that decision in the screening test. That's my point. It is the Commission who has taken the policy decision. Commission can always say that my policy is right, my policy is good, but these petitioners can say, since we have participated in the selection process in 2024 written test, we want the result. That they can say, but they cannot say that the screening test was bad. That's my point. Because they have not challenged until 2024. And that's all. Level playing field already argued by.
Already argued. Any other writ petitioners?
I am handing over the judgment of
ওটা নিয়ে নাও তো কল্যাণ বাবু। I will not give the case number, WPA number. That is in WPA number
26090.
6090 2020.
Whatever.
Yes, commission is the fundamental villain. So real quote and unquote Ravun is the commission. Now let us see whether the Ravun can become the greatest worship of Rama. Well, I would be beginning with something completely different from our world. There is a common thing I think all of us face, like at while we are at home, maybe I'm looking for my pencil or a pen or a watch or whatever it is. If that thing is not in its usual place, I don't know what is the neurological reasons. Most of us, we don't see that, no matter that is there. So I was reading one of the articles there. The neuroscientists, they found that no matter there are A to Z things which are in existence in front of 10 persons, but not necessarily that the 10 persons would be seeing A to Z in the similar fashion. It will vary based on, they use a different term based on the environment and others. So I would use for my purpose based on what I expect to see. Well, I have understood the case of the petitioners, and I found what the petitioners are saying. If that is correct, then practically no sensible lawyer can justify the conduct of the commission. That's my first finding, because as a responsible counsel, I cannot say if I find the submissions what they have made, if that found to be correct. So therefore, my endeavor has to be either there is a fundamental flaw on what they are saying, similar to either something is missing, something is not there, or there is a completely different things altogether, what is yet to be, what was not brought before your lordship. Well, I just made just a, for bird's eye view.
On behalf of commission, for commission, not for commission.
Well, this will give this, I don't know, this has a lot of reflection. Now, may I just broadly indicate the points that, my lord, I would be addressing. Well, I stand on that reasonable point. Yes, the submissions and what they have said, what they have expressed, if that is an watertight fact and law, I have an extremely bad case, no doubt about it.
Yes, Mr. Dhar.
Yes. Now, lordship may first, before seeing anything, kindly take this, the bird's eye view of list of dates. But the advertisement was March 10. The rules, lordship may skip rules part, that is not that much important. Then, Mala, there was the preliminary screening. Well, I will pause for a little moment. But this preliminary screening part, lordship will see that in the rule there is an expressions that my learned friend has also expressed. Assuming the rule doesn't say so, the consistent view of the Honorable Supreme Court is this, that even if rule doesn't say, if the number of candidates are more, you can always go for a preliminary screening, because this is not going to be added up in the final competitions. So it is fundamentally huge populations, unmanageable. So it has to be cut down to a working percentage of the competitors.
Basic concept is for elimination.
For elimination, correct. One word is the eliminations, right? So whether there is a rule or there is no rule,
nobody is, it is not a challenge.
No, it is not. Why I'm saying this, my only purpose of making this submission is to indicate that there is a difference between preliminary screening watertight nature versus the original competition's watertight nature. In the preliminary screening, I would say it is little relaxed in comparison, only in contrast, not otherwise.
Mr. Dhar, I'm sorry for interruption.
Yes.
I believe the object of holding preliminary examination is for elimination.
Yes.
And the object of holding written examination is for the selection.
Correct.
Am I correct?
Absolutely. Absolutely. So therefore, when the object is to reduce the number of competitors, all of whom are eligible, it's not for the purpose of empanelment. It is just the first door to enter in the competition room. Whatever happened, well, I will address this is later on. My only purpose was that there is a fundamental difference between these two objects. As I would borrow Lordship's word, screening equals to
Dhar, will you please spare me for 2 minutes?
No, before third, I was on my lord, third, 28th November 2010. Malad, this is the bone of contention. Lordship may mark it. That preliminary screening, it happened in 3 sessions. Malad, one information I should say, even in these very preliminary sessions, for each session, the question papers were different. It's not that same question paper. And in intra session, it was in permutation and combinations. So November 2010, that was that quote and unquote for the purpose of elimination preliminary screening. That was an OMR based in 3 sets. And each set, my lord, whenever say there is a hall, so that no illegal method is adopted, the question number 1 to say Mr. X.
I know.
Yes. So that is in 1 session. But
I had some experience
that
holding recruitment examination of the district courts, at least in 6 districts.
So
I know that process.
So I need not say anything on that. So that permutation combination. Now, only thing I need to say that permutation combination in intra-session, but completely different question altogether in other 2 sessions. So 3. Now Lordship may see thereafter May 2011 that 26,445 who participated in the written examination. Now that's written examination is no more an elimination round. This is actual competition itself. It has to be watertight. That's my understanding. Now, my lord, the most important part, which I don't know for what nobody has said, nowhere it was said, the Madrasa Service Commission Act constitutionality was challenged. And in March 2014, our court declared section 8, 10, 11, 12. 8 was the section by which the rule was framed, was ultra vires, Article 30. So effectively, the commission became defunct. Now, this was challenged by the commission before the Honorable Division Bench. The Division Bench, my lord, in December 15, even declared the entire act to be unconstitutional.
Act means
the Madrasa Act. Entire was unconstitutional. So the commission practically completely defunct, no functioning of that. Then the commission challenged the matter before the Honorable Supreme Court. Now, if Lordship kindly skip for a moment this Shomen Malaka's case and kindly turn to next page. It was only in January 2020, the Honorable Supreme Court, by the judgment reported in 2020, 6 SSC 689, set aside the single bench judgment and as well as the division bench judgment.
So it has become intravirus.
It became intravirus. So therefore, there is a long period from the date of declaration, that is from March 14 to January 20. If I can use the word, not even hibernation. They were not there. Now, to say that why there is no functioning, kindly look at I'm first trying to give the context of the situation. Because the Showman Malakar came in 2018.
Sorry, Mr. Dhar.
Yes.
You come to the first page, sir.
Yes.
Written examination was held on 29/5/2011.
Yes.
Yeah, the several sections have been declared ultra vires on 12/3/2014.
Yes.
That is, after few months later than three years.
Correct. Correct.
So what are you doing there at that time? 3 years.
Let me say that there was it was a repetition of 2013.
Had it been your case?
Yes.
That on account of.
No, that's not my entirety case. No. First, I'm just trying to give a context because this context was not.
No, that context must covers the period of inaction on the part of the commission right from 30th May 2011 to 11/3/2014.
Well, I'll come to that because I would not make a submissions which is not even at all convincing to me. So therefore, my endeavor would not be that on my part, there has not been any iota of flaw that I will not make that submissions.
Very good, sir.
My fundamental submission shall ultimately be, if I say the crux of my submission is, as a selector, if I discover or if I find, and because today also I have all the OMR with me, the original OMRs with me, and also the answer key. If I find there are 3 sessions, that answer key of session 2 has been used for all the 3 sessions, meaning thereby for session 1 and session 3, the large number of persons for no reasons were left out. When I'm coming to the legality, of course, I have to and I would. As a selector, if I see that, I have 2 choices. Either I shut my eyes and I decide, let that cancer remain there, no matter what happens, wherever. This could be one approach. The other approach would be, I say whatever it is before the Honorable Court. I would place my both cards. That this is the situations I saw, this has exactly happened.
If the action of the, or rather if the thinking of the commission is so bona fide,
yes,
then what prevented the commission to approach the court?
Yes.
As you have said, as in your second limb of submission,
true.
What happened? What prevented the commission to approach the Honorable Division Bench
to
or further extension of time or
that I will come.
Or reviewing the orders passed in the division bench.
That part I will come.
Account of disclosure of some material facts.
That part I will come because that part I might be able to show before your lordships that something all of us were missing.
No, for non-moving the division bench, your action has become really susceptible in nature.
May I say this? May I say this? I have understood. So lordship is beginning from the understanding that the division bench have said X. Let us understand X, what they said. Lordship is beginning from that.
No, sir. I am on practically on the provision of Order 47.
Yes.
Of the Code of Civil Procedure.
Yes.
On account of sufficient cause.
Yes.
Which could not be placed.
Yes.
একটু দেখি ভাই এই কল্যাণ বাবু এই সিপিসিটা একবার দিন তো এই সিপিসি or for any other sufficient reason.
Yes. Which is
according
enough.
to the commission.
Yes.
The commission has sufficient reason. What is the sufficient reason? Disclosure of the facts that on account of some technical error,
yes,
some successful candidates who ought to have been permitted to be participated in the written examination have been left out.
Right.
So provisions of Order 47
Correct.
empowers the commission to approach the division bench even in a review
Correct.
on account of disclosure of our subsequent events,
Correct.
which comes under the purview of sufficient cause.
Yes. Then why I did not?
Yes.
Yes.
That is my question.
I understood, man. I understood the question. My direct answer is I did not because it would be very bold. There was no requirement. Now there comes that I began with the neuroscience example. I would show before your lordships the order of the single bench, and I would show the order of the honorable division bench. Most likely, I would be able to demonstrate what has not been demonstrated. Well, I will come to that after just finishing this few pages. Now, well, I have given this that the resurrections happen, that is in January 2020. Now, then Malad division bench judgment February 20, and thereafter taking this Malad 2014 the other. But this part is not necessary. Rest parts, on fact, there is no such dispute. Now, may I straightway come to the single bench order?
Page 94.
Yes, Melo, that is page 94, which is at page 65 of the writ petition. Lordship is seeing page 65 or 94? Both same thing.
Your comprehensive.
I was thinking maybe Lordship, since petitioners speak fast, so I thought that
I will take from there, no issue. I will take that one.
That would be better because
very good. For your convenience, I can do. Hey, Babu, Kulan Babu, আমার বইটা দিন তো ভাই।
I'm extremely sorry. Would your lordship, because before placing the order of the honorable single bench, may I place the writ petition's prayer and then come? For writ petition's prayer, my comprehensive would be required.
Just
Well, my only purpose, that is at page 71. The prayer, page 71 of my page 71 of my comprehensive. The entire writ petition has been annexed and we found at page 71.
71 of what?
Of the comprehensive opposition.
Page 71 is the
prayer
copy of the writ petition of WPA 24588.
WPA, Somen Malaka WPA number ta dekho.
Oh, it is in respect of Somen Malakar's case?
Somen Malakar, yes.
Oh,
yes,
I see.
Because that is
I
the
understand.
main thing.
Give me a second. I have noted wrongly.
172 W of 2018. It's of the comprehensive document.
Yes.
This is 1722 W of 2018. Now, first Lordship, kindly take the prayer. The prayer is to forthwith publish the result of the written examination. The first paragraph, page 71. And if I can read it fully. To forthwith publish the result of the written examination on first state level selection test for the Group D post peon conducted on, kindly see the date, 27th of March 2011, which is a different date than my list of dates, which is a different date. So, and if Lordship looks at the writ petition also, which starts from page 59
Of your
of my compilation, yes. Well, I was reading each paragraph with an endeavor if I can find anything to do with the fundamental issue relating to any wrong in the screening test. Lordship will find a complete absence of that. This is a clear case of examination is done, please publish the result, and that's all. Context, when the commission is defunct because of the same being declared ultra vires. So therefore, the entire writ petition, there is not even
Yes.
the entire writ petition, if I can use this, entire writ petition is confined to examination done, publish the result. Examination done, publish the result. Nothing else. Now, in that context, Lordship, kindly come to the learned single judge's order. That is, for this purpose, I was saying to see writ petition, but Lordship can see also because order is the same thing. Page 94 of the this compilation, sorry, comprehensive affidavit, and page 64 of. Now, Lordship, kindly see what was the exact order. Internal page 2, second paragraph. This is the all order. And I would say this order remains watertight because this has been upheld by the Honorable Division Bench. So this cannot be tweaked. This remains. Well, may I read it? Accordingly, the present writ petition, which was by a sole person, Mr. Malakar, and this showman Malakar, my lord, he is not one of the petitioners here, is disposed of after recording that the writ petition did appear in the examination of such and such on 29th May 11. Well, kindly link with the prayer. He said a different date. So ultimately there was a confusion that was clarified. Fine. And not much such and such as submitted by both the learned advocate for the writ petition and Mr. Diwan, learned counsel for the commission, and by directing the respondent number 2 and 3 to forthwith intimate the writ petitioner the result of the evaluation of answer script. This is one part. Second part, and this is the contingent part. If he is qualified, then to prepare the panel in terms of Rule 18. And if he is eligible, I'm coming this part later on. Lordship may kindly mark the contingent part of the learned single judge's order. If he is qualified, then to prepare the panel. Whether I'm not into correctness, I cannot. But this has been upheld. First part, intimate the result. Incidentally, he was not qualified in this case. So as far as this order itself, leaving aside all other, because independently my other actions can be challenged and can be found to be completely wrong. But to say that my action is wrong because the learned single judge decided something contrary to my actions may not be factually correct. All my endeavor is the confining area in the order of the learned single judge.
Mr. Dhar.
Yes.
So far as the communication of the result.
Yes. That's a publication.
Mr. Malakar.
Yes.
Is one part that
Yes.
I understood.
Yes.
So far as preparation of panel, if he is qualified.
Yes.
Does it not mean?
Yes.
The publication of the result?
Of course it does. It does. Of course it does. But I would
without publication of the
absolutely
result, you cannot
correct.
prepare the panel.
Correct.
Result means the result of all the candidates.
Correct. But my entire endeavor would be, I shall be trying to screen myself.
This way or that way, you have been directed to publish the result.
Right. I take it that. And that is so. I was only trying to say this. May I say this? As an advocate and also as a devil's advocate. I am trying to say that I stand by both. I say that there is an order which has a contingent part of it. But I'm not saying I want to take any benefit out of it. I say there is a possibility of making an interpretation of this order that the panel publication is dependent on if he is qualified. But that interpretation I am not taking.
No, Mr. Dhar, try to visualize in this fashion. You may accept or you may not accept. Preparation of panel is subject to the publication of the result.
Yes.
The division bench, while deciding the appeal.
Well, division bench kindly do not come now.
Sir, please listen to me.
Yes. Sorry.
The division bench, while deciding the appeal, passed several orders.
Yes.
In that orders, your clients approached for extension of time for publication of the result. So, by your act,
yes,
you have accepted the order of the single bench, and by your act,
yes,
you have given assurance to the court that you will publish the entire result.
Correct. I stand by that. I stand by that.
So how can there be, Mr. Dhar, there be a different interpretation?
May I say this? I am not trying to take advantage of any possible different interpretations. Not at all. I am completely agreeing with this part and this interpretation that sum and substance of the order of the Honorable Single Judge was publish the panel, prepare the panel. If we understand lucidly, I go with that. Now I put a question here. What does it mean? When a writ petition is placed before the Honorable Single Judge saying there is a delay in publication of panel and the Honorable Single Judge directed publish the panel, does it mean that the Honorable Single Judge had the occasion to deal with any of the aspects of the preliminary or flaw or anything else?
Definitely not.
So I will come to division bench if I go step by step. So therefore, as far as the Honorable Single Judge's order is concerned, it was confined to delay in publications, preparations, do that. This much. Now, if the Honorable Single Judge's, the entirety of the order is this, either it has to be expanded by the Honorable Division Bench, which is the case of my learned friends, or the order remains so. Why I am saying this? my endeavor is that today it is a case before your lordships where your lordship is completely free to say I was completely wrong. But I was wrong. To prove that I was wrong, showing this single judge's order, because single judge has said X and I have violated this, that may not be correct. Well, if I can little elaborate. Single judge direction is publish the panel. This was not the issue before the single judge, that what happened in the examinations. It was neither here nor there. Therefore, the sum and substance, the A to Z aspects, the ratio of the honorable single judges, this order is publish the panel. Now, publish the panel if the ratio, publish the panel if that is the parameter. Either the division bench have expanded publish the panel into something else also, or division bench have made it more concrete by affirming it. Now, while doing so, if there are some observations by the division bench, what are those? Whether those are binding before your lordships, that lordship is required to follow it definitely, or lordship is completely free to look at the issue minus the division bench judgment, minus the order on the issue of subsequent aspects. My answer would be based on the consistent views of the Honorable Supreme Court, at least in 10 judgments. Because the judgments are not statutes. Unless the issue is there, in this case, there was no issue. Well, may I say this? Because my second limb of argument has to be that what I did, that is justified or that is not illegal. That is, if I can say that, if I can use these lucid terms, sometimes we often see we are not able to see the things in either in complete black or in white, as most of the things in the world. That's in shades. Even in metaphorical term also, most of the things we see around, most of the things are in shades. So all I'm trying to say, there is a possibility that my submissions may not lead my client to be a complete situations of absolute white. It could be shade. But once I am able to show before your lordships that my subsequent actions happened because of a situations like, kindly visualize, as a selector, I can be malafide, like that has happened, Supreme Court 26,000 case. That's possible. As a selector, it can also happen that when I have all the original records and I see in the screening, how come this 73,000 were completely left out? Now, my choice is of what should I do? Should I remain silent? Let it happen. It doesn't matter because something has happened. Or I say it, because the moment I say it, it would not fall in polarized state. Because one of my arguments could also be in here, I will make before your lordships. If lordship finds that it is really not possible, because it started from 2010-11, if situation is such that it is really such cancerous, if lordship feels at all, I may not even stand in the way. If lordship feels that there is even a requirement of setting aside of its entirety for both. If I'm only saying if, because my entire endeavor would be to place the entire card, including the law part, that if a selector finds that these candidates, they participate in the screening, but their screening papers, which are with me even today in the locker room, those were screened by a different answer key. Now, once it is done by a different answer key, if Lordship kindly see this, then what happens? It is luck. Let us say the answer key says that A is correct, B is incorrect. Now, and that answer key was meant for say session 2, not for 1 and 3. But that was used for 1 and 3 and also 2.
Mr. Dhar, you being a model employer comes under the periphery of Article 12 authority.
Yes.
If you are so generous, if you found yourself so responsible, I'm putting, and you are so apathetic to those candidates who according to you have been wrongly left out.
Not only those, I think all.
Very good.
All.
Then again I am putting this question,
yes,
that why you have not chosen to place your cards
yes
before the honorable division bench?
Right. But there could be two situations.
Huh.
I might have thought
You are
that
so responsible, you
correct.
are so generous.
True.
You are a model employer.
Correct.
Then why have not approached the
But I'm a model
Apple
selector.
Very good, model selector.
Yes,
Be that
because
as it may.
ultimately employment.
Yes, absolutely. Model selector.
Yes.
So
Why I did not
no,
approach?
there is a really susceptible in nature.
But no doubt about it. When I started studying these cases, I was exactly with the same expressions that I have seen with my learned friends and also lordships. Whatever.
I am with your argument that before the honorable coordinate bench, when this order was passed, this situation cannot be foreseen. 2018. But during the pendency of the mat before the honorable division bench, you found it difficult to publish the result within the stipulated period. You approached twice or thrice for extension of time. Cost was lastly imposed. Then all on a sudden, you publish the notification dated 5th August.
Yes.
You publish the second notification dated 9th August.
Which are challenged.
Challenged.
Right.
Scope of review is there.
But I'm yet to come to division bench order. But lordship is whatever I say, I can see that lordship is taking me to the honorable division bench's order. But that of course that's my the hardest hurdle. But there is a likelihood that lordships might see it differently. There is a because I was saying to my juniors also.
Sir, earth is down.
Yes, true.
At 4 p.m.,
true.
If I can see the sun,
true.
It is
True.
setting.
True.
And if I sit at Alaska or Los Angeles,
True.
I'll see this rising.
True.
So, view changes, sir.
It does.
On account of change of angles.
True.
Show me the different angles from where I can perceive your case.
Absolutely. Because my lord, and my lord, this is also, I don't know, that's the kind of school that somehow, if I find that I shouldn't say, it is very difficult for me to say that. Very difficult. But that has got nothing to do with, I just said. Now, may I come to the division benches? Well, Lord, may I, in a very unusual fashion, may I read the division bench order reverse? The last portion first and thereafter the other portions. There is a reason for it. Kindly come to Lordship is writ petition, page 68.
Order dated?
This order dated 4th of February 22. by which 6 more months were granted. I will place the operative part. Thereafter, I will deal with all the quote and unquote, my hardest obstacle parts.
Order dated?
Order dated 4th February 22. Well, that is
That number, page number 99
page
of
number
your
68.
composite.
I think Lordship has marked in the writ petition while hearing the writ.
While doing my homework.
Sorry. Our case actually started in vacation.
What can be done? You all found it.
We are. No. Mala, here is the thing. Mala, we are fighting here, a metaphorical fighting. But on one aspect, I think there is no divergenting any one of us. That this is one of the finest benches. My lord,
pampering is not good, sir. Please. At the age of 55 or 56, pampering is not good, sir.
My lord, those who know me, they know that I hardly pamper.
Be that as it may. Thank you for your kind words. Yes, sir.
Yes.
4th February.
Yes, my lord, 68. So I said, I will do a reverse reading. 68, last paragraph. Because no matter what is observed, I said, no matter what happens, ultimately it boils down to operative portion of the division bench. So that I am on at page 68, last para. In view of...
Give me a second, sorry. Yes.
Well, last two. In view of the subsequent stand now taken by the appellant, we do not delve, appellant is me. We do not delve to go deep into the legality and infirmity of the impugned order. Thereafter, the impugned order is modified to the extent that the appellant is directed to complete the exercise, kindly mark, strictly in terms of the directions passed in the impugned order within 6 months. Well, I am only on the words strictly in terms of the single judge's order. Is it an expansion of what the single judge said? Or it is a more confinement, more concreteness, more watertight?
Yes. So this is the first order which is passed in the division bench.
Yes,
in the appeal.
It's the first order. I can go to the second order also, but I have to deal with, there are other parts I must give answer. But before giving an answer, all I want to say is ultimately the Honorable Division Bench direction was strictly comply with the single judge's order, which means publish.
Absolutely.
Which means the issue, whatever was there in the writ petition, the issue, whatever was there before the Honorable Single Judge, that remained. No other issue was touched upon. And that was also, we do not, that's the paragraph, last but one from the bottom, we do not delve to go deep into the legality and infirmity of the impugned order. So all I'm saying is, there could be thousands of observations and sentences in the entirety of the judgment. And ultimately, there is an operative part of the judgment, of the order. Now, if Lordships weighs both, first interpretation has to be that those observations are the reason for this operative portion of the order. That has to be the by default. Assume that by default is not possible by applying the prudence mind. That assuming that those observations and reasoning have some expansion nature itself, but the operative part is a confining one to the point, strictly in terms of the order. Then what to do? Well, there are answers very consistently that all the observations which were not germane to the issue do not have any binding effect, neither that can be said to be
Yes, Mr. Thor.
well, I could have understood that the Honorable Division Bench did not touch any portions of the judgment. That did not happen here. The Honorable Division Bench actually tinkered with the order, timing portion, 6 months. So therefore, the only thing which was changed by the Honorable Division Bench, expressions and others there, I will make submission on that. The only thing which can be said to be beyond the Honorable Single Judge's order was timing and nothing else. My second point is, the moment the Honorable Division Bench uses this word strictly in terms of the direction passed in the impugned order, that makes it even more concrete that the Honorable Division Bench did not want to address any other issue. The Honorable Division Bench wanted that exact directions of the Honorable Single Judge that needs to be complied with, but 6 months more. That's the only part. There are various observations, but those observations, sorry.
Yes, Mr. Thor.
Kindly visualize two categories. One, I am delaying to comply with the order. Two, I am seeking to expand the scope of the writ petition or the single judge's order. Because the appellant, it was me. It's not the Showman Malakar. He did not go. He did not challenge it. I went, I lost. Now, when I lost, there was a delay. Now, the delay there, let me put it this way. I want to make submissions against myself. That those delay, let us assume that those delay, I was completely irresponsible. As a proper selector, I should have been much more competent. So there was a delay.
So, Mr. Thor, would it be your argument? If I'm wrong, please correct me. The situation as prevailing now, the situation as was prevailing on account of disclosure of your technical fault, so-called technical fault, was not there when the learned single bench or the Honorable Division Bench passed the order and affirmed the judgment. Would it be your submission like
But
this?
I'm completely speechless. I can't even use a single semicolon. Yes.
It is your contest.
Yes.
Let me note, sir.
Varun.
Yes, sir.
Okay. Well, I was trying to find out the what's the correct view expressed by the, or what's the view by the Honorable Supreme Court exactly on this, and I have been able to collect a good number of judgments which directly addresses these situations. First, কোনটা দেবো বলো? Just 2014. First, my lord, 2014 13 SCC 707. Paragraph 26.
Just commission note করবে না 26 sir
2014 13 SCC. Yes, sorry.
2014
It is very
13
difficult
SCC.
to match with the speed of your lordship.
SCC 707
Yes,
paragraph
Correct,
26.
26. My lord, may I just read?
Yes, sir.
Watson's law lexicon defines the term obiter dictum as an opinion not necessary to a judgment, an observation as to the law made by a judge in the course of a case, but not necessary to his decision, and therefore of no binding effect, often called as obiter dictum, a remark by the way. Kindly pausing for a second. In the entirety of writ petitions, there is a zero regarding what is today before your lordship. Before the Honorable Division Bench, that is also not there. The only appeal by me, not by them. They want learned single judge was right. We are happy with it. The ultimately Honorable Division Bench also echoed the same. Single judge was right strictly in terms of this. But in the meantime, because of the delay, some observations are there. I have to deal with that.
Over then anticipated prevailing situation.
Correct.
In subsequent orders.
Correct.
Of the division bench.
Yes.
Because you raised the point.
Yes. I did not raise the point. If I say very honestly, all I did, I messed up the thing like anything. From day one to whatever day. That was my feeling. I could not understand why this was not brought to the division bench, even single bench in 2018, that I was defunct.
Mr. Dhar, so far the principle of obiter dicta is concerned, I believe it is attracted when court passes a remark over an issue which is not in issue, which is not subject matter in issue, the suit or trial or appeal or something.
Absolutely.
I understand your content, sir.
So therefore,
the situation which is prevailing now,
yes,
or which you disclosed on account of the technical fault,
yes,
was naturally not there.
Yes, naturally.
But sir, in at least one or two cans, you have expressed, and there is a clear-cut observation of the Honorable Division Bench to that effect.
May I just give, because now 2 minutes.
Yes, sir. I have to dispose of one application again.
Yes. Do.
What application? Which application, sir?
But in 26090.
একটু বার করো।
আরে addition of party আছে। আমি যাচ্ছি কি আছে?
অর্ডার বুক গুলো একটু দাও। পেনটা দিন আর অর্ডার বুকটাও দিন।
Can 2 of 2025.
In WP,
26090.
that was not disposed of.
No, my lord.
Huh?
My subsequent.
একজন
It is apparent. And I'm already
তাছাড়া
দিয়ে একবার দেখি অর্ডার বুকের আছে, কালকে তো হলো ওগুলো সব আমরা করলাম তো।
ঠিক আছে।
ওয়েট করুন, ওয়েট করুন। ওহো, 26090.
My lord. Can 2 of 2025, my lord. It is appearing in the list, my lord. List আছে।
That is can 1 of?
My lord, can 2 of 2025, my lord.
There is no such can. লিস্টে দেখা শো করছে?
Yes, my lord.
Have you got a copy?
Your lordship has partly disposed of that can.
Show করাবে। Have you got a copy, sir? You are the advocate on record.
No, my lord, Mr. Shakhwat Khandakar is the advocate record, my lord.
Is in present court today in court. Very good.
সব মামলা
আসুন তো ভাই, এটা লিখুন
Lordship, may I be permitted to mention this matter? I had mentioned yesterday, Your Lordship, to be tagged with these. It's the matter that was filed before the circuit bench, Your Lordship. The difficulty is that it cannot be tagged with these matters because there's a common.
Madrasa matters?
Yes, Your Lordship. It cannot
Oh,
be tagged because
follow,
it is a common number, Your Lordship.
Huh? No, if there be a judicial order, it ought to have been done. Where is the order of tagging?
The order, I have submitted the order at the time of mentioning, Your Lordship.
Let this matter be tagged with the other writ petitions. Mr. Dhara, I'm asking an academic question to myself. Yes,
Just write a letter
that you
to the
can
chief.
do. Get it assigned to me, I will take up the matter. But prior to the passing of the judgment, because tomorrow is the last day.
Yes, Your Lordship, that is the difficulty. Placing it before the Chief Justice will take some time, Your Lordship. And
I cannot
Look, that would
I cannot
Lordship
wait for
cannot
that.
Lordship
I
cannot
cannot wait for that. এটা করা যাবে না, কিছু করা যাবে না।
Just like may I point to one thing, because my learned senior friend is time and again said,
This was fixed for long days.
I can continue, my junior should be there. If he is finished, then only I'll get a chance. Like Mr. Gauri is continuing. So you should take it. Grateful one.